Except that the author, I'm not going to make his arguments because I'll let him make the arguments. He's presented to me, the trial de novo requires everybody to be fair, or requires to be honest in the assessment that you make, or as well as the Board of Soups that are doing.
And that's no different now than it is for the appeals board. One of the fundamental differences is when we move into litigation and you have a little assessor's office fighting an airline industry, it's virtually impossible on a dollars basis. And that changes that dynamic from where you have a regulatory agency like a PUC who has a regulatory authority versus a local appeals board or a county who just doesn't simply have the resources to deal with an industry at that level in some cases. So it reduces it to an appeals board level.
But if we took out the discount, and we said, lead agency, you do the assessment of what you believe the value of the airplanes in your district are, and that's all the court's going to be able to look at when they look at de novo. They're going to have, it's not like there's this new, you're going to say, okay, these are the airplanes, this is the best information that we had, we're assessors, we've been doing this for 20 years, this is the fair valuation that we put on the fleet, and it is, why would the judge not affirm the true valuation at the market valuation that you would make? What new evidence would be coming in unless you had done something unfair or had improperly or not thoroughly valuated the merchandise or the airline?
Maybe that's a fair question, but why wouldn't that standard be applied to every other taxpayer in the state at a local SAC level? Because
they don't cross county lines. I keep going back to 1910. They don't cross county lines. They're in county lines, and that's why you're a hybrid, whether they like it or not.
There are many industries that cross county lines that are assessed locally. Even simple businesses cross county lines that are assessed locally. Many. I mean, there are thousands, millions probably.
Last question, Senator White.
No,
You're done?
Okay, yeah.
Senator Monning, followed by Senator Morlock.
Thank you, Madam Chair. My question, I think, to the author for starters, and then maybe to the opponents. What's the argument for extending the discount valuation system at this point? My understanding is that it was calculated post 9/11 to accommodate huge losses in the airline industry. My understanding that's not the current status quo of the airline industry economy. Why continue the discount and using the lower valuation level?
Well, first of all, I don't think it really came out of that. I mean, this story is something that's all new, at least from me, as I've been doing my due diligence with respect to this, to try to create a picture. But it's not a discount. It's a formula that's a presumption that either side can approve or not approve, right? It's not a tax break. It's an evidentiary standard that's going to be used, and you can disprove the assumption based upon circumstances that came out of a series of litigation and a whole bunch of other stuff. And it's this notion, not about a single aircraft, but that a fleet of aircrafts, because fleets are valued less, past my pay grade, past that, okay? But that's the framework. So it's gotten framed as if it was some kind of tax break for the all-powerful industry, when in fact it was a negotiated deal. Personally, you know, from my standpoint, it's a presumption. I look at it like as you as a lawyer, and it's just an evidentiary presumption. It's completely different. I would just, you know, I just want to go back on this bigger issue. I think what Senator Rakowski said is that, well, you know, these guys initially, the airline people, wanted to go directly to the government, to the Board of Equalization, just like all the other big utilities do. And the idea of meeting a middle ground was this hybrid thing. And the last thing I want to share with you that's really important to know about this argument that makes no sense to me is Mr. Nazarian has a bill in the other house that has the exact same formulas supported by the assessors. And that bill doesn't have trial de novo, and there's no question about it. Right? So my point to you, and truly getting to the essence of it, as we all know from being in this business for a long time and hearing arguments, you throw up on the board whatever you got to throw up, but the real target is, it's about power. Do not let the courts question me and look at what I'm doing. And my point is, the courts have a right at the end of the day to always review this kind of thing. We're giving you a hearing, we're giving you assessment appeal board, but let's get a right to hear.
Thank you. But if I could, Madam,
Go ahead, please.
ask one of the assessors
Please.
to respond to my question about the rationale for this, what's presented as a discounted valuation.
Having not been involved in that directly, but speaking from the perspective of the assessors, and what I understand it to be, it was a concession or standard made after 9/11, and that has continued to move forward.
And how does your association feel about that?
I think underlying it in the ideal level, we would look and say, well, if 10% discount is market value, why don't we just call market value the standard? And move away from this 10% number. Just if 10% is an adjustment, that's fine. It's still market value. That's really the true standard.
Yeah, it would seem that market value would be the standard unless a case can be made why there should be some adjustment.
I mean, that stands on its own 2 feet, market value.
Thank you.
Senator Morlock.
Thank you, Madam Chair. Mr. Benson, you're a constitutionally elected officer of your county, is that correct?
That's correct.
And are all 58 counties independently elected assessors?
They are, sir.
And so your focus is basically on fairness of fair market value. That's what you're doing. You're representing the taxpayers. You're not there. You're not a tax collector. You're not a tax revenue agent. You are just an assessor.
And it's not because I'm just a constitutional officer. That is the law of the land of California in the United States, and one of the most fundamental principles of our land, that everybody is taxed fairly and by the same standard.
And we've got about 12, maybe more counties that actually have airports, so we're kind of a unique state.
That's true.
What has been the problem with your association in showing a leadership with a lead agency and making it work?
Well, you know, I spoke at the very beginning. I've been in this business for 30 years, and I can assure you, from the smallest taxpayer to the largest taxpayer, it seems to be that if anybody could take their choice, they just wouldn't want to pay taxes. So taxes are just kind of a naturally American way of saying, you know, am I paying the right amount of taxes? And if I don't think I am, do I dispute it? Nobody argues with that debate. That debate has been going on at appeals boards and the courts forever. It won't end no matter what this committee does to move forward. Suffice it to say that, you know, it's not easy reconciling big cases with big taxpayers. It's hard work. Is this unique to this industry? No. Large industries, I mean, you can look to the oil industry or any other industries in the state of California. You're going to find the same problem. It's not an easy answer. We're going to try to work to some resolution on it, but I think the assessors are most interested in finding a method or a methodology that's consistent with all the other property we assessed and working with the industry where we can to find some resolution.
But this is a possessory tax that we're talking about, where a commercial airline lands on a public airstrip, and we charge them personal property tax for the time they're there. So all, I'll say 12 for the sake of discussion, because I've been listing all these counties that actually have active airports. But they're all going to get the same data from the FAA to make sure that they have accurate data. And you've got the plane model, probably the year built. You've got all the data you need for your depreciation schedules, et cetera. And it just seems that if one lead agency, let's say LA County, just to make it simple, they've already got Long Beach, they got LA, LAX, and you pay them out of the other 11 counties to take care of preparing the possessory tax reports. I'm trying to figure out why that isn't working and why you spent some 7 meetings with Assemblyman Nazarian, and we still don't have a resolution to kind of get, you know, something working with everybody here.
Well, that's a very good question, and I think At the end of the day, when it doesn't work or one party or another may not get the resolution they seek, they look for alternate solutions. The solution here is to go before the Assessment Appeals Board and hear the case and let it take its course through the local Assessment Appeals Board, even if we're adopting the lead agency, as you've mentioned, which the assessors have said. That's what we're prepared to do to move forward.
Well, then would your Assessment Appeals Board, say in LA County, you could even have someone that actually knows the airline industry be one of the 3 members of that hearing board? Would that be something you've?
It's conceivable. There are many, I don't know how many. I can tell you from Marin County, we have industry experts that serve on our local Assessment Appeals Board. They work for industry. That is their professional job. I am not the only county in Marin County that has examples of members of their appeals board that work for industry and are taxpayer advocates. So is that conceivable?
I would
It
just
certainly
charge
is.
you, I just encourage you that we've got to fix this problem. Last 3 questions. 1, what is Article 13, Section 19?
I'm sorry, I think that references Article 13,
Constitution.
Section 16, which
16,
basically
okay.
says that the Constitution, the California Constitution, sets forth that the local equalization or assessment appeals board is the authority to hear cases at the local level on the merits of the case. And that's different from trial de novo. That is the constitutional authority that says it's local equalization.
And then how many cases have gone to Superior Court?
On the airlines industry or at large?
Airline.
I'm not sure. I don't know if you can speak to that, Mr. Parker.
Yes, Senator, I can tell you that in the past 10 years, only 2 AAB appeals in Los Angeles County have gone into the court system, one filed by United and one filed by American. And as far as I know, they are still in the court system being litigated.
That's just LA County.
Yes, sir.
So San Francisco could be different, San Diego could have cases.
Yes, sir.
Then on the endorsement or the support of this bill, your entire association is opposed or just your board is opposed?
The association took a vote in opposition.
Is that all 58 or is that just
Well,
the
through the
board?
executive committee, the executive committee voted to oppose it.
And then Orange County's not on the executive committee then?
I'd have to look at the list. No, I can tell you they're not.
Okay. Thank you, Madam Chair.
If I may, this question. A part of, I think, where I'm having an issue is the notion of a de novo, a trial de novo. Why can't everybody come in at the first stages at the assessor, put all their cards on the table, the assessor makes its decision, it goes to an appeals board, all cards on the table, and then it goes to a court, perhaps for review, but not for de novo. I'm a little concerned about if we were to you know, I can see some of the games that get played. I'm a lawyer, used to do this too. You figure out where your best chance is and you hold your cards close to your vest until you get to your best shot at something. So if you would answer, and then I see you shaking your head afterwards, would you respond to that?
Of course, Madam Chair. Thank you for the question. What you've talked about is the way the system has been set up by the state laws to date and to the Constitution. That is, the assessor sets the value, and when the taxpayer gets the news and they don't agree, rightly or wrongly, doesn't matter, the Constitution gives them the right to file an appeal with the Assessment Appeals Board. And the Constitution intends for the AAB to be the equivalent of a trial court if you were talking about normal litigation where you have all the factual disputes heard, all the legal disputes heard, you have a decision on everything that is presented based on all the evidence. And in fact, AABs don't even have to follow the strict rules of evidence. So you could get into evidence anything relevant that a trial court doing its normal function might say, I'm sorry, you violated whatever evidence code, you can't bring that in. And then the trial court, if the losing side, whether it's the assessor or the taxpayer, doesn't like what the AAB decided, the trial court acts as a district court of appeals would. It makes a de novo review of all the legal issues made in the appeal, I'll call it the appeal for the moment,
It's a separate entity, correct?
That's correct, ma'am, yes. And looks at the factual determinations on the abuse of discretion test. Was there any or sufficient evidence or not at the AAB level to support the factual determinations that went into the AAB decision? The answer is yes or no. That, the trial court does review that.
Thank you. Gentleman in the back.
Sure. I think what you posited is that somehow this change would result in taxpayers using the current system as sort of a dry run. Let's sandbag, let's keep our arguments.
Not necessarily, but possibly.
Possibly.
Yeah, I'm not saying it would.
But the point
but
is
it could.
that we're currently required to put all of our grounds into an administrative claim for refund, or when you get to court, you're thrown out because you didn't exhaust your administrative remedies. You are required to put all that on the table. You are required to have a full hearing. The problem is, and he identified it, at the administrative level, from county to county, how these boards operate varies greatly. Some aren't bad, but some are really, the assessor starts with recommending who gets appointed to them, and even in some cases recommend exactly which cases get referred to which boards, whether they're favorable or unfavorable to the assessor. The truth of the matter is that the property tax, the locally assessed property tax, is the only tax in California where you don't have a trial de novo. It's the only one. Bank and corporation tax cases, huge corporate cases, you take it to the FTB, FTB appeals it to the BOE. When you go to court, it's a trial de novo.
But these are on the state level.
Local taxes as well. This is true even with, you pick it, utility user taxes, business license taxes. When I file, if I'm challenging a business license tax, it's a trial de novo. And as a matter of fact, California is one of the few states in the nation that doesn't have trial de novo for its locally assessed property tax cases.
But so if it's locally assessed, there isn't de novo, but if it's assessed on a statewide basis, it is.
It currently does. And again, the court has jurisdiction to substitute its own judgment on legal issues currently. So then you get into this big fight over, well, is it a factual issue or is it a legal issue? And then it all turns into a court game over how it's characterized. Because if it's characterized as a legal issue, the court can do whatever it wants to do. But what he touched on is the standard that the court uses to evaluate that administrative record, which is, they said, under the current standard, if there is any conceivable way, if there's any conceivable evidence in the record, then they're compelled to support the decision, even if the preponderance is, if there's 5% supporting it.
Then what you're saying is you don't like the standard. There's so many things going on here.
Yeah.
Oh, Senator Leno, do you?
The standard is certainly the core issue in it. But yes, because
No, enough, because Senator Leno has got very limited time.
And committee members and Senator Hertzberg, I'm got to get back to public safety to present a couple bills, but I've been listening very carefully, and I do have a few thoughts to share and also a few questions to ask before I leave. So, Mr. Benson, you had reminded us of not an insignificant point, which is what makes this industry different from all others, certainly at the BOE or the CPUC, is it's deregulated. This is a very different kind of industry. And so that puts it in its own category from my perspective. Out of concern for what kind of Pandora's box, if you can call that, or just precedent that this might be setting. In your conversation with Senator Wachowski, you had said that there are many industries that cross county lines, and could you give us some specifics as to who might also want this de novo if we provide it for airlines?
How about Target? How about Home Depot? How long do you want me to go on with the list? One of the fundamental differences that surfaces in the concept that you bring forward is, do all those other industries then come forward to us and say, well, if you're doing this with the airlines, I need to look at, and I'm going to challenge the local assessor under the U.S. 14th Amendment for equal protection. Because if you're doing it for them, you should be doing it for me. And when you talk about a Pandora's box, that's it.
Would you not recognize that there's difference between stationary and mobile assets? Does that,
There very well could be, but even on mobile assets, we can look at things like boats and other type of things that travel back and forth between counties that may be locally assessed.
ferry services from San Mateo to San
Certainly.
Francisco?
Certainly.
They could easily want to get this de novo. So I've spoken with San Francisco's county assessor, and though San Francisco International Airport, given that it is in San Mateo County, this will not directly impact my county assessor, but out of concern for what precedent this might set, not unlike ferry services or others that could also want this de novo. She points out that San Francisco has a backlog of around 15,000 pending assessments due to all of the construction that's going on in San Francisco right now, 15,000. And that if she had to go into a courtroom to defend an assessment from her office, that whichever industry it might be, that she would have to divert staff, and it could be, and dig in a very deep and legal way, not only the administrative action that was determined by the court, or could be determined by the court, but also the assessment determination that would be determined by the court. And she thinks she'd also have to call in the city attorney for assistance. So this is a lot of additional city-county expense, which will not be reimbursed in any way. So that has given her serious pause. I did also want to return to this 10%. I was here in 2005. I think some of us were. And my memory is, as yours, Mr. Benson, that our colleague Assemblyman Horton authored the bill that created this valuation scheme, which I'm reading from it. The assessor shall identify the value referenced in the, quote, use price of average ACFT wholesale, unquote, column of the winter edition of the airliner price guide by make, model, series, and year of manufacture, and deduct 10% from that value for a fleet discount. 10% discount, that is 10% less than they were paying before that. The valuation. The valuation is deducted. 10% is deducted.
The reason is, Senator, is because the price guide is set up for sales of one aircraft. That's not the market value of a sale of a fleet of aircraft, and that's what that's supposed to reflect. So it is market value, but of a sale of a fleet.
I understand that. And in this industry, I don't know that we would ever be talking about anything but a fleet. No?
That's actually what distinguishes it from what the gentleman said. We're not talking about just like a target. What's being assessed here and what this bill is limited to is actually only a fleet of airplanes. Think of it as an amorphous mass. We're not valuing individual aircraft. We're valuing a mobile mass that's really one unit, and it's being spread between states and between counties. And so that's, I'm sorry, so I'm just to finish the thought. So that's what makes this different, not regulation, is that it's really one asset that's moving.
Mr. Benson, if I may, through the chair.
Please.
Was this the case prior to 2005?
Sir, I don't know before 2005. It wasn't my area of expertise. I'm not sure if
My understanding is it
Mr. Parker
was not. It was created in 2005.
I would concur, Senator. It's my understanding, I've been in this business since '94. It's my understanding that prior to 2005, each county assessor on his or her own calculated however they best could
There was no,
the amount of planes taking off and landing at the airports in their jurisdiction. And so they tried to figure out, without reference to the big picture, if you will,
right.
what was going on.
So my understanding is that prior to 2005, that this deduction of 10% from the value for a fleet discount was not in place, and this was a change. You have some information, Mr. Benson?
So I think what had happened was that after 9/11, there was a significant reduction in airline travel across the country, and that was an effort on part of the assessors to address that change in market value per se, based on what had been the prior historical standard of market value because of that unique experience of 9/11. And if I may, Senator, respond to your question about, or your point about the volume, should we adopt trial de novo in circumstances like this, you're absolutely right. Assessors struggle across the state to keep up with their number of appeals. And the unfortunate outcome that I could foresee, should we be drafted to take so many cases to court, is, we don't try to keep everybody at the standard. We just settle cases. That's not what we do in taxation.
So as not to keep public safety waiting too much longer, I'm just going to conclude with this, and it's a broader perspective. I hope I'm not the only one who's got these thoughts in my head, because I'm trying to be specific also to the bill. But from my experience serving in the legislature and on this committee where we deal with these issues, industry, consumer impact, and I'm thinking, how does this impact my constituents who are consumers of this industry? And the airlines has come to the legislature, to us, not once, twice, 3 times, 4 times.
3 times.
Well, in
This is
2005.
the first time it's been this bill.
No, but with regard specific to the 10% deduction for the value of the fleet, 2005, with a sunset. Assemblywoman Ma came back in 2010, extended the sunset for a second time. 2015, Assemblyman Nazarian, extra years so we can have some time, and now this proposal to extend it another 5 years. That's a repeated requests. And now, in addition to all that, we want de novo. And my question has to be, you're deregulated, what do we get? And let me just finish the
Yeah,
thought.
please, of course.
And I can't not be mindful of reading a news story, and I'm not here to claim I know the details of it all, but Senator Schumer was attempting to do a little something for all of those Americans who travel on our airlines, because I think we all know what it's getting to be like on those coach flights. It's not only not pleasant, it's something you really don't look forward to. And if you're aged or disabled or you've got an infant, it's a living hell. And what this Senate bill tried to do to this deregulated industry was get an extra couple inches between rows and a slight 3 or 4 degrees in pitch of the seat. And the industry said no, and they killed the bill. So you want, and you want, and you want, and you come back, and you come back, but what do my constituents get out of it? I don't see anything. And so I could debate the de novo back and forth. I'm not an expert in this. I think both sides have made reasonable arguments. I have no idea why we keep extending a sunset. My experience with sunsets is you put it out there, see how it works. Maybe you extend it a second time, or you just repeal it. But now a third and a fourth time, I'd like to know why we don't just repeal it altogether, but another, because I think it's a benefit to an airline that I don't know what, if it was deserving in 2005 when revenues fell precipitously. Now, the major costs to the industry, fuel prices plummeted, prices went up, and seats got closer together.
Yeah. Can I just, before you leave, Senator,
Sure.
if I could just share my thoughts in that regard, because I certainly understand the emotional point that you raise, and I certainly don't think it's defensible, and, I'd be on the other side of that one, really don't know. But as it relates, often in government, the Constitution requires that even the most unsympathetic characters get fairness. It's not about them, it's about us. It's about what kind of society we are and whether or not we as a society have a set of rules and a rule of law, and do we treat people fairly. That is what got my attention. Not that all the times I get out of a seat with a backache, which I completely agree on. So point number one is I think it's about us. Secondly, They are regulated. It's regulated at the federal governmental level, just like the railroads are regulated. They're regulated. What those regulations are, the FAA, there's a whole series of regulations as to how that works, right? But the larger issue, I just want to suspect in terms of what you get is this. We have tax dollars, right? First of all, it's a sense of ethics and fairness about how you treat even the people that are unsympathetic. And secondly, it's a waste of money. The reality is, look, these people are required, just like we had in the traffic tickets issue earlier today in public safety, to put the money up. They got to put the money up. They got to write the check. They got to deposit it. So when you look at the issue of the fact that somebody is trying to, I need the money, I'll make a deal. The other guy's got the money, just like somebody who holds the money, and you want to get it back. To me, it relates pretty significantly to the issue of fairness. And so, I think it is a fair question. Leon Panetta always asks that question, how would somebody in my constituency agree to this? What would that look like? At the end of the day, there's 44 airlines we're talking about that affect California. To me, I look at this, maybe wrongly, but seems fair to me, that had this certainly been the issue in California at that time, when airlines would have been in public, this would have been part of the play. And that what you have is a sense of power, of local government folks throwing anything against the wall. And I'll close on this for purposes of your question. Any other questions people have is this. This is their idea. This was an agreement. The reason for the multiple bills is that the parties agreed to this process of a lead agency. The bill that they support that's sitting in the other house, it's like talking to both sides of your mouth, is this formula. I don't give a rat's about the formula. They agree to it. They've all agreed to it. The County Assessors Association picks the lead county of these handful of counties that have airports and makes a determination. That's their bill. I've just continued that process, and all I want to do in order to create equity and fairness in this process is to say, let's change the game, because you end up having this so one-sided in terms of the alignment of the interests. That's what captured my attention, and that's why I carried the bill, and that's my focus. But I certainly would stick with you on those seats, man.
All right, I think with that, there are no further questions. On the fairness question, which is why I asked, how many instances do we have where there are outrageous results and where the appeals process is weighted and loaded, and that there is a lack of fairness? I'm not satisfied that information was sufficient to warrant my support of this. I'm not taking, for my colleagues, I have no recommended position. Each person, I think, well, you always have the ability to make your own decisions here. I have no recommendation to make on this bill. And with that, is there a motion? I'd like to close it out very quickly, please, Mr. Witkowski.
There's 3 members have talked about the 10% discount, and I feel a little uncomfortable. I'd like to move the bill, but I would like to have that provision taken out. I don't know how my other colleagues feel like, but I'm willing to make the motion on the de novo review and those other elements if the author was prepared to do that. I know that.
Yeah, as long as it's prospective, it doesn't affect current cases, it seems to me. It's got to be prospective in terms of the stuff and have a discussion on it. But if that's the issue, that's the only issue they're talking about, because they already have the formula.
I'm going to get a handle on this. Are you suggesting that Senator Hertzberg agreed to that amendment?
Yes.
All right. And Senator Hertzberg, are you willing to accept that amendment?
Yeah. What I'd like to do is
we're going to remove the 10%.
Valuation.
For valuation purposes.
On a prospective basis.
On a prospective basis.
current
That's your
cases.
request? Are you willing to accept that amendment?
Yeah, if I get the votes.
Well, all right.
And I move the bill as amended.
Okay.
All right. The motion is to pass as amended to Senate Appropriations.
Jackson,
Not voting.
Morlock, Anderson. Anderson, aye. Hertzberg.
Aye.
Hertzberg, aye. Leno. Leno, no. Monning. No. Monning, no. Witkowski.
Aye.
Witkowski, aye.
Vote is 3-2. We'll place it on call. And we'll be closing that out. We've got two more bills, Senator Senator Mendoza, and then I have a bill, and that will be closing our session.
Thank you for the committee's time.
We are on the